It happened behind the heavy doors of a federal courtroom in Washington, D.C., but the shockwaves are now rippling across American politics. What was supposed to be Donald Trump's most aggressive legal counterattack has instead become a moment many legal analysts are calling catastrophic for his defense. A federal judge didn't just say no. She erased every path forward. 14 arguments, 14 rejections, and a written ruling so detailed that it may redefine how presidential immunity is treated going forward. This wasn't a narrow procedural loss. This was a full-scale collapse of an appeal strategy that Trump's team believed was their last line of defense. The setting alone signaled that something serious was about to unfold. On January 14th, inside courtroom 6A of the federal courthouse in Washington, Judge Sarah Chen took the bench precisely on time. She has handled high-profile federal cases for years, but what followed would stand apart from anything in her tenure. Trump's attorneys arrived with what they described as their most comprehensive appeal strategy yet, built around constitutional claims they believed could freeze the prosecution entirely. Instead, they walked into a judicial buzzsaw that left even veteran court reporters stunned by its precision and severity. At the center of this showdown was a bold legal gamble. Trump's team constructed their appeal around four major pillars: permanent presidential immunity for actions taken while in office, double jeopardy claims tied to earlier investigations, allegations of venue bias, and accusations of prosecutorial misconduct. On paper, it looked expansive. In reality, it was fragile. As Judge Chen began questioning the defense, it quickly became clear that she had reviewed every filing line by line. Her questions weren't general. They were surgical, grounded in Supreme Court precedent, and aimed directly at the weakest points of the defense's logic. The tension inside the courtroom escalated when the immunity argument took center stage. Trump's lead attorney argued that prosecuting a former president for official acts would permanently damage the presidency itself. But Judge Chen interrupted with a single devastating question, referencing Nixon versus Fitzgerald and the distinction between civil and criminal immunity. That moment changed everything. According to reporters in the room, the confidence on the defense table visibly drained away. What followed was not a debate. It was a methodical dismantling. Case by case, precedent by precedent, the judge laid out why the immunity claim didn't just fail. It contradicted decades of established law. And this was only the beginning. As the hearing progressed, it became clear that the court wasn't simply rejecting arguments. It was documenting a pattern. By the time Judge Chen began addressing the remaining motions, the atmosphere had shifted from legal advocacy to damage control. Observers noted long pauses, whispered conversations among Trump's lawyers, and a growing sense that the strategy they had spent months preparing was unraveling in real time. The stakes were no longer abstract. This ruling would shape not just this case, but how future courts respond to similar claims. What makes this moment so explosive is what comes next. The written decision spans 47 pages, and according to legal experts, it does far more than deny motions. It establishes a roadmap for rejecting similar defenses elsewhere. And when a federal judge reaches that level of clarity, appeals become far more dangerous than helpful. In Part 2, we'll break down exactly how Judge Chen dismantled each argument, why the double jeopardy claim collapsed even faster than the immunity defense, and how this ruling may have boxed Trump's legal team into a corner with no clean exit. Once the immunity argument collapsed, Trump's legal team attempted to regroup. Their next move was the double jeopardy claim, a theory built on the idea that previous investigations had already placed Trump in legal jeopardy, making this prosecution unconstitutional. On paper, it sounded complex. In the courtroom, it unraveled almost instantly. Judge Chen didn't raise her voice or signal frustration. Instead, she asked a question so precise that it froze the room. Could the defense cite a single federal case where an investigation alone was treated as a formal criminal prosecution under the double jeopardy clause? According to court reporters, the silence stretched on long enough to feel uncomfortable. No case law came, no precedent followed, and that pause told the judge everything she needed to know. When the defense tried to reframe the argument by claiming unique circumstances, Judge Chen shut it down immediately. Federal courts, she explained, do not operate on vibes, narratives, or political context. They operate on law. Investigations are not prosecutions, reviews are not indictments, and disagreeing with how prosecutors exercise their discretion does not create a constitutional violation. With that, the second pillar of the appeal strategy collapsed just as decisively as the first. Legal analysts later noted that this exchange alone would have been enough to sink the appeal. But Judge Chen wasn't finished. She was building something larger, piece by piece. The third argument, alleging venue bias, was supposed to shift the battlefield entirely. Trump's attorneys claimed Washington, D.C. was inherently hostile territory and that their client could not receive a fair hearing there. Judge Chen responded by demanding evidence, not opinion. Had any juror been improperly selected? Had any ruling shown legal bias rather than political disagreement? The answer, again, was no. Disliking a defendant's politics, the judge reminded the court, is not evidence of judicial prejudice. Federal courts have handled organized crime figures, terrorists, and government officials in the same venue for decades. Political discomfort does not invalidate constitutional process. Then came the prosecutorial misconduct claim, the defense's final attempt to salvage momentum. They alleged that the prosecution's decisions were unfair, aggressive, and tainted by political motivation. Judge Chen addressed this argument with what observers described as barely concealed impatience. Prosecutors are allowed to be aggressive, she said. They are allowed to make strategic decisions. What they are not allowed to do is violate defendants' rights. And the defense had failed to show a single instance where that had occurred. Disagreement with outcomes is not misconduct. Losing arguments does not equal abuse of power. With that, the final pillar crumbled. At this point, the courtroom atmosphere shifted completely. This was no longer about whether Trump would win a motion. It was about how badly he had lost. Judge Chen announced that she had reviewed all 14 motions, along with more than 300 pages of briefing, and found none of them persuasive under established federal law. Each claim, she explained, had either been directly contradicted by Supreme Court precedent or previously rejected by multiple circuit courts. This wasn't a close call. It was a clean sweep. And the language she used made that unmistakably clear. But the most dangerous moment for Trump's legal team was still ahead. Judge Chen went further, warning that repeated attempts to delay proceedings through baseless constitutional arguments could trigger sanctions. In federal court, that word carries weight. It means professional consequences, licenses, reputations, careers. Legal experts immediately recognized the signal. The court's patience was gone. What had begun as an appeal had now crossed into something far more serious, a judicial determination that the defense strategy itself was bordering on obstruction. And this is where the stakes truly explode. Because once a federal judge documents a pattern of frivolous litigation in a detailed written ruling, that record doesn't disappear. Other courts read it, other judges cite it, and appeals courts defer to it. In Part 3, we'll examine why this ruling could reshape Trump's legal future far beyond this single case, how historical parallels are already being drawn, and why many experts now believe this decision marks a turning point in the battle over presidential accountability. By the time Judge Chen began reading from her written ruling, it was clear this hearing had crossed into historic territory. 47 pages. That number alone caught the attention of legal analysts nationwide. Federal judges don't spend that much time unless they're building something meant to last. And as Chen laid out her reasoning, paragraph by paragraph, it became obvious this wasn't just about Donald Trump. It was about drawing a hard line between political power and legal accountability. Each page reinforced the same message. Former presidents are not exempt from the rule of law, and the courts will not bend simply because the defendant once held the highest office in the country. What made the ruling especially devastating was how thoroughly it closed the door on future appeals. Judge Chen didn't rely on one or two precedents. She cited dozens, including Supreme Court decisions that explicitly rejected the very theories Trump's team was advancing. United States versus Nixon, Nixon v. Fitzgerald, circuit court rulings spanning decades. The message was unmistakable. These arguments weren't new, bold, or innovative. They were old, settled, and repeatedly rejected. Legal experts immediately noted that appellate courts tend to defer heavily to trial judges when rulings are this detailed and well-supported. In other words, this wasn't just a loss, it was a trapdoor. Then came the moment that stunned even veteran court observers. Judge Chen addressed Trump directly. That alone was extraordinary. Pretrial proceedings rarely involve direct judicial commentary to defendants, especially former presidents. But Chen's tone was calm, measured, and devastating. She made it clear that the court would not entertain arguments grounded in personal belief, political grievance, or self-defined constitutional theories. The law, she said, is not flexible based on who is standing before the bench. When a judge speaks that plainly, it's not a warning. It's a line in the sand. The broader implications were immediate. Legal scholars began drawing comparisons to Trump's past courtroom defeats, from the collapse of his 2020 election challenges to repeated rejections of executive privilege claims in the classified documents case. In those moments, courts dismissed arguments. This time, the court documented a pattern. That distinction matters. A documented pattern of frivolous filings becomes a weapon against future defenses. Judges in other jurisdictions can point to it as evidence that similar claims deserve swift rejection. And that's exactly what experts believe is happening now behind the scenes. Within hours, commentary from across the legal spectrum poured in. Even conservative scholars who have historically supported broad interpretations of executive power acknowledge that the ruling was airtight. When a judge cites more than a dozen Supreme Court cases to dismantle immunity claims, there is no ideological spin that survives scrutiny. The law is the law. And for Trump's legal team, that reality creates an impossible dilemma. Continue pushing arguments that courts have now labeled baseless, or abandon the narrative that has defined Trump's legal defense for years. This is why many analysts are calling this ruling a watershed moment. It doesn't just affect one case, it reshapes the terrain for all of them. Cases in Georgia, Florida, and New York now exist in the shadow of this decision. Every immunity claim, every delay tactic, every constitutional challenge will be measured against Judge Chen's analysis, and the more courts align with it, the narrower Trump's options become. The legal system, once fragmented across jurisdictions, is beginning to speak in a unified voice. And yet the climax doesn't end in the courtroom. It spills into the political arena, where reactions have been swift and volatile. Trump's response, rather than engaging the legal reasoning, turned personal and incendiary. Legal experts warn that attacking judges instead of arguments only strengthens the court's position and weakens the defense's credibility. In Part 4, we'll break down the fallout from this response, the political and constitutional consequences now unfolding, and why this moment could permanently redefine the limits of presidential power and accountability. As the dust settles, one thing is unmistakable. Judge Sarah Chen didn't just reject a legal strategy, she dismantled an entire worldview. Her ruling makes clear that presidential power has limits, and those limits do not vanish once someone leaves office. For Trump's legal team, the consequences are immediate and severe. 14 motions denied, a 47-page ruling anchored in Supreme Court precedent, and a formal warning that continued frivolous filings could result in sanctions. In federal court, that combination is rare and dangerous. It signals that the court is no longer willing to entertain arguments designed to delay rather than defend. Beyond this case, the ripple effects are already being felt. Federal judges in other jurisdictions now have a detailed legal blueprint for rejecting similar immunity and double jeopardy claims. Appeals courts, which typically defer to thorough trial court analysis, will have little room to argue that Judge Chen misunderstood the law. This means Trump's legal options are narrowing fast, not just here, but across every pending case. What once looked like an aggressive constitutional strategy now appears boxed in by its own overreach. Politically, the fallout has been explosive. Trump's reaction, attacking the judge instead of the ruling, has deepened the divide between legal reality and political messaging. Legal scholars warn that personal attacks on judges rarely help defendants. They often harden judicial resolve and weaken credibility. At the same time, Trump's supporters see this moment as confirmation of a broader political crisis, while critics view it as long overdue accountability. Either way, the stakes extend far beyond one defendant. This is about whether the courts can enforce constitutional limits when political pressure is at its highest. At its core, this ruling reinforces a foundational principle of American democracy. No one, not even a former president, is above the law. If courts allow endless constitutional theories to delay accountability, the rule of law erodes. Judge Chen's decision draws a firm boundary, reminding the country that power flows from the Constitution, not around it. That message will echo through courtrooms and campaigns alike in the months ahead. And now the question turns to you. Do you believe federal judges should have the authority to shut down constitutional arguments they deem frivolous? Or does that power risk overreach? This conversation is far from over, and what happens next could shape the future of presidential accountability in America. If you found this helpful, comment your thoughts below, hit like, and subscribe to our channel. Don't miss the next update.